A setback for Vedanta NCLT rejects TSPL demerger. The National Company Law Tribunal, or NCLT, plays a crucial role in India's corporate landscape. It oversees mergers, acquisitions, and corporate restructuring. Its decisions have significant implications for businesses operating in the country. Recently, the NCLT delivered a blow to Vedanta Ltd, a prominent Indian conglomerate. It rejected the demerger scheme of Talwandi Sabo Power Ltd, or TSPL, a Vedanta subsidiary. This decision has sent ripples through the Indian business world. TSPL operates a large power plant in Punjab. It was meant to be a key part of Vedanta's ambitious plan to split into 5 separate entities. The NCLT's rejection has thrown a wrench into these plans. This essay will delve into the reasons behind the NCLT's decision. It will analyze the arguments presented by the parties involved. The NCLT's rejection highlights the complexities of corporate restructuring in India. It underscores the tribunal's focus on transparency and creditor rights. The decision has also raised questions about the future of Vedanta's demerger plan. The company is now left to evaluate its options and chart a new course forward. The missing debt, a Rs1, 251 crore oversight. At the heart of the NCLT's rejection lies a significant financial discrepancy. TSPL's demerger scheme failed to disclose a Rs1, 251 crore debt owed to SEPCO Electric Power Construction Corporation, or SEPCO. This omission proved to be a fatal flaw in TSPL's proposal. The NCLT viewed it as a violation of the Companies Act, 2013. The debt stems from a 2016 consent award in SEPCO's favor. It includes USD 138 million and an additional INR 122 crore. This amount constitutes over 75% of TSPL's unsecured debt. The magnitude of the omitted debt raised serious concerns for the NCLT. The tribunal questioned the transparency and completeness of TSPL's disclosures. The omission of such a substantial debt from the creditor list is a major red flag. It suggests a lack of due diligence on the part of TSPL. The NCLT's rejection serves as a stark reminder that companies must exercise utmost care and transparency in financial disclosures. Failure to do so can have severe consequences. SEPCO's stand, challenging the demerger. SEPCO, a Chinese company specializing in power infrastructure, played a pivotal role in the NCLT's decision. Represented by Cyril Amarchand Mangaldas, a leading Indian law firm, SEPCO challenged the demerger scheme. They argued that the omission of the Rs1, 251 crore debt was a deliberate attempt to sideline their interests. SEPCO's legal team presented a compelling case before the NCLT. They argued that the debt's omission prevented their participation in crucial creditor meetings. These meetings are essential for creditors to understand the financial implications of a demerger. SEPCO also argued that the missing debt would significantly impact the valuation of TSPL post-demerger. The potential for a negative net worth for TSPL post-demerger was a key concern raised by SEPCO. They highlighted that the debt's inclusion would paint a drastically different picture of TSPL's financial health. The NCLT found SEPCO's arguments persuasive. The tribunal recognized the significance of the omitted debt and its potential impact on creditors. Section 4. TSPL's defense, a matter of timing and jurisdiction. TSPL, represented by Hemant Sethi & Co., attempted to defend its position before the NCLT. They argued that SEPCO's intervention in the demerger process was premature. TSPL claimed that the debt was related to a separate legal dispute over a registered office change. This dispute, they argued, was under arbitration in Singapore. TSPL's legal team emphasized that the debt was acknowledged in its financial statements for fiscal years 2019-20 and 2022-23. They argued that the debt was reflected as a foreign currency exposure. TSPL assured the NCLT that they were committed to provisioning for the debt once the dispute resolution process was complete. The NCLT, however, remained unconvinced by TSPL's arguments. The tribunal found it difficult to overlook the magnitude of the omitted debt and its potential impact on creditors. The NCLT also questioned the timing of TSPL's disclosure. The fact that the debt was only acknowledged after SEPCO's intervention raised suspicions. Section 5. Vedanta's ambitious plan, a 5-way split. The NCLT's rejection of TSPL's demerger scheme is a significant setback for Vedanta Ltd. The company, led by Anil Agarwal, had embarked on an ambitious plan to split into 5 separate entities. This move was aimed at unlocking value for shareholders and streamlining operations. The demerger plan received board approval in September 2023. Vedanta secured the necessary approvals from stock exchanges and garnered the support of shareholders and creditors in February 2025. The plan was well on its way to implementation before the NCLT's decision. The 5-way split was designed to create independent businesses in key sectors. These included metals and mining, oil and gas, power, aluminum, and semiconductors. Vedanta believed that this restructuring would allow each business to focus on its core strengths and attract targeted investments. The NCLT's rejection has thrown these plans into disarray. Section 6. Implications of the rejection, delays, and uncertainty. The NCLT's decision has far-reaching implications for Vedanta. The most immediate impact is the delay in the demerger timeline. The company had aimed to complete the process by the end of fiscal year 2025. However, the NCLT's rejection necessitates a reassessment of the situation. The delay introduces uncertainty into Vedanta's operations and future plans. Investors and stakeholders are left wondering about the company's next move. The setback could also potentially impact Vedanta's credit rating and access to capital markets. Moreover, the NCLT's emphasis on transparency and creditor rights sets a precedent for future corporate restructuring in India. Companies will need to exercise greater diligence in their disclosures and ensure that the interests of all stakeholders are adequately addressed. The NCLT's decision serves as a timely reminder of the importance of good corporate governance. Section 7. The road ahead, appeals and potential outcomes. In the wake of the NCLT's rejection, Vedanta has confirmed its intent to appeal the decision. The company maintains that it is committed to the demerger process. Vedanta will likely argue that the omission of the SEPCO debt was an oversight. They will need to convince the appellate tribunal that it was not a deliberate attempt to mislead creditors. The outcome of the appeal remains uncertain. If Vedanta's appeal is successful, the demerger process may resume, albeit with some delays. However, if the appellate tribunal upholds the NCLT's decision, Vedanta will need to revise its demerger scheme. This could involve addressing SEPCO's concerns and potentially renegotiating the terms of the debt. The NCLT's decision serves as a stark reminder of the complexities of corporate restructuring. It highlights the importance of transparency, due diligence, and stakeholder engagement. The outcome of Vedanta's appeal will be closely watched by the Indian business community. It will have significant implications for the company's future and could potentially influence corporate restructuring practices in India.